Namaskar, I'm Milind Pan Patil, Director, National Water Academy, Pune. Warm welcome to all senior officers from the Ministry of Jal Shakti, then Central Water Commission, and other departments, as well as State Water Resources Department, then IITs, NITs, and different institutions from the India who are dealing with the water sector. I also warm welcome to our today's eminent speaker, Shri Chetan Pandit sir. Sir, before start the session, we will first of all briefly introduce to our today's speaker, Shri Chetan Pandit sir. Shri Chetan Pandit sir is an former member and ex officio additional secretary to the Government of India. Shri Chetan Pandit sir graduated in civil engineering from IIT Delhi and obtained his MTech in hydrology from Galway, Ireland. He joined Central Water Engineering Services through UPSC Engineering Services and worked for over 35 years in Central Water Commission as a Central Water Engineering Service Officer and other organizations under Ministry of Water Resources. His significant assignment includes Member Secretary in Upper Yamuna River Board, then Chief Engineer, National Water Academy, Pune, and Executive Member, Narmada Control Authority. He retired in March 2012 from the position of Member and ex officio Additional Secretary to the Government of India, Member Water Planning and Project in Central Water Commission. His core interests are hydrology, telemetry, simulation studies, and policy and governance issues. Post-retirement, he has become known as a consultant for interstate water disputes in India. Presently, he is working as a consultant and expert witness for the state of Goa for Mahadai river water dispute since 2014, for the state of Chhattisgarh for Mahanadi river dispute since 2018, and for the state of Telangana for Krishna river water dispute since 2021. Now I request our today's speaker, Shri Chetan Pandit sir. Sir, kindly enlighten us on the topic of today's Interstate River Water Dispute Tribunal. Sir.
Thank you very much. And first of all, my sincere apologies for having to postpone this lecture suddenly from the given time, morning 11 o'clock to now. An unexpected meeting regarding the Chhattisgarh dispute came up and it had to be postponed, but I can see that there is still a large number of audience. Thank you for accommodating me. Now, let me start the sharing the video first. Yes. Are you able to see my shared screen now?
Yes, sir. Yes, sir.
Okay. The topic for today's lecture is actually a description or an explanation about how the Interstate Water Dispute Tribunal works take place. The CWC officers or all of us, all of you are aware that a state having a dispute with another state files a complaint with the Ministry of Water Resources under the Interstate Water Dispute Act. And then after giving a reasonable time for amicable solution of that dispute, if the amicable solution does not take place, then the ministry has to constitute a tribunal as provided in the Act, and a matter is handed over to the tribunal for further adjudication. We also know that the tribunal consists of 3 members who are, one of them is a Supreme Court judge, the other 2 are High Court judges, and they get 2 senior engineers, usually but not necessarily retired officers from CWC, to help them as assessors. So far, the story is known to everybody. Then what happens? After the tribunal is appointed and they get their office and all the equipment, everything together, and the assessors are appointed, then what happens after that? The engineers who are working in the State Water Resources Department, some of them working on the resolution of any interstate dispute, they get an opportunity to know how a tribunal functions, what happens after that. But the engineers working in the CWC never get that opportunity because we don't actually work with a tribunal anytime. And also those who are outside the CWC or state government WRD community, say academicians in various colleges, etc., they also do not get an opportunity. So that is the topic of today's lecture, that what happens after the tribunal is constituted and takes charge. I will take maybe about 1 hour to little more than an hour to give a small presentation, and thereafter we can use any remaining time for the questions and answers. This you already know. The water dispute tribunals do not have to, but generally they follow what is known as civil procedure code. They have to follow some procedure. And I think the reason they follow the civil procedure code is that that is the only code that all the legal community is familiar with. And this is something that they have been practicing for years. They are familiar with it. So they follow that code. However, following the CPC, the degree of severity can differ. As I gathered from my seniors and others who have been involved, the Narmada and the Krishna Water Dispute Tribunal 1 have been somewhat informal. Relatively, the Mahadai and the KWDT 2, that is Krishna Water Dispute Tribunal 2, have been relatively more rigid in conforming to the code. And what is meant by somewhat informal and somewhat more rigid, that we are coming to as we proceed. The complaints referred by the MOWR to the tribunal for adjudication is called the main matter. Typically, what happens is that the entire complaints submitted by the state government is forwarded as it is with a 1-line forwarding request is forwarded hereby for adjudication of all matters arising out of it. That is without any further comment or any editing. This is called the main matter. In addition, parties may also file before the tribunal what is known as IAs, that is interlocutory applications. An interlocutory application is a application to a court in any matter which is already in the process before that court. A smaller part may be submitted as a interlocutory application. Say, for example, for an interim relief till the main matter is decided. Every party appoints, to start with, an advocate on record, or known as AOR. AOR is also a regular advocate as anybody else. They have to pass a additional exam conducted by the Supreme Court, and on passing of that, they are declared as advocate on record. For our purpose, we can consider the advocate on record like a authorized input-output port for the party. Suppose a party wants to submit something to the tribunal or to another party. Who exactly from that state will submit it? It can't be that anybody can submit anything to the tribunal and the tribunal has to accept it. So who is the authorized person? That is the advocate on record. Likewise, anything you want to communicate to a party, starting simply from the simple thing like the date of the next hearing to anything else, to whom do you communicate it? Again, you communicate it to the advocate on record. So practically the AOR functions primarily, in addition to being an advocate, he functions as the input and output port for the party. Now from this point onwards, anything which is served by a party to anyone has to be served to all other parties. Now the word served is a word used by the legal community. To submit some document or some notice or anything is called serving, like serving the summons. So anything served by a party to anyone has to be served to all other parties. There is no one-to-one communication here onwards. Even a simple thing like requesting the tribunal for condonation of a delay in submission of a certain document, even copies of that have to be served to all the parties. And all submissions to the tribunal have the status of a sworn affidavit. Therefore, they have to be drafted very carefully before they are submitted. Now, in this flow diagram, I am briefly showing you the process as it takes place from the beginning to the end. And then hereafter, we are going to discuss each component of it separately. The first, there is something called pleadings. Again, what is pleadings? We are coming to that. Pleadings of a party is a party pleads their case through some documents. So in the beginning, there are pleadings. Then the issues to the disputes are framed. Simultaneously, some data may be exchanged between the parties to help each other to form their views or complete their studies. Then there is submission of evidence. Each party submits some evidence in form of documents to prove whatever they have pleaded in their pleadings. Then the cross-examination of the witnesses starts. People who have submitted evidence in form of expert studies, they are cross-examined by the opposite sides. After this, the arguments start by the advocates. There are oral arguments and there could be even written submissions. And then finally comes the decision from the tribunal on what is known as decision 5.2, that is section 5.2 of the Interstate Water Dispute Act, which decides all the matters referred to it. The Act gives the parties an opportunity to seek clarification after that, and that is called 5.3 proceedings, section 5.3. Again, there will be a bit of hearing, submission of some documents, etc. And then the tribunal gives their decision on the 5.3 also. Sometimes we call the decision of the tribunal itself as an award, but that is not correct. Tribunal only submits a report to the central government. When the central government notifies that report in the Gazette, then only it becomes an award. Correct? Now, in the blue box, I have written SLPs. This is not provided for in the Act. SLP, you know what it is, special leave petition. There is no provision for a SLP in the Act, and the Act is very clear that the decision of the tribunal is final and binding on all the parties. However, starting with the Kaveri River water dispute, SLPs have been submitted to the Supreme Court challenging the decisions of the tribunal, and that creates something new, which is why I have put a red question mark in front of it. This is basically the structure or the process followed in the tribunal. Now let us look each component in more detail. As the tribunal takes charge, the first thing they do is they direct all the parties to file what is known as statement of case, or SOC for short. This word we are going to hear again and again in the future. A statement of case is basically where a party says out their grievance in detail. It has two main parts. One is the facts of the case, and second is the prayers, or what is the relief sought from the tribunal. So first you explain the entire scenario, what is happening, who is doing what, who is constructing what project, giving you, not giving you water, causing flood or anything. You explain all the case, and then you seek the relief from the tribunal, say 1, 2, 3, 4, this is what the relief you are. You want to restrain the other party from constructing a dam, you want to restrain them from using more water than a certain amount, and so on and so forth. So there are two parts, facts of the case and the prayers. The SOC of a party is called its party's pleadings. That is where the party has pleaded before the tribunal their case. Now, what is the significance of pleadings? There are three important reasons why the pleadings have a very important place in the process. The first is to prevent the case being expanded or grounds being shifted during the trial. See, what happens is, in any civil suit, one of the parties will stand to benefit by extending the dispute. That is, by maintaining the status quo for as long as possible. Typically, a downstream state who is using already a lot of water compared to the upstream state will have an interest in prolonging the proceedings by continuing the status quo. Therefore, if you allow a situation where a party can create new issues as the trial is proceeding, then it will go on endlessly and will never end. Therefore, the first requirement is, of the pleadings is, that once you have pleaded something, you can't go beyond that. to prevent a case being expanded or grounds being shifted as the process is going on. So the rule is, or the law is, a party can submit evidence only on issues or points raised by them in the pleadings. If they forget to raise something in the pleadings, they can't raise that, they can't submit issue or submit evidence on that later on. So the you can say the dimension of the dispute is frozen to whatever points they have raised in the SOC. The court is also required to confine their decision only to the questions raised in the pleadings. The court cannot go outside the pleadings and give decision on something which no party had asked for. Court cannot grant a relief and also the court cannot grant a relief which is not claimed and which does not flow from the facts and the cause of action alleged in the complaint. That means the complaint, that is the pleadings of all the parties taken together, confine everyone, the parties as well as the court, to now not go beyond what is stated in the pleadings. So now the dimension of the dispute cannot increase beyond this. The case is frozen to the issues raised in the pleadings. The second reason is fair trial. The opponent should not be taken by surprise. This is not a game of cricket where you ball a googly or something called dusra and suddenly take the batsman by surprise. Fair trial requires that what you are generally going to plead should be known to the other party so that they prepare their defense accordingly. There is some request. Anyway, I will. So, you give notice to the party as to what your case is going to be so that they can prepare their defense accordingly. You give notice to the opposite side. The opposite side also similarly gives notice to you. The third reason is to ascertain the main points on which the parties differ. This is called issues of the dispute. I mean, basically a party has said that they want more water or they want you to use less water. But then you have to crystallize into some very specific issues on which the trial and the decisions will take place. So these issues will arise out of the pleadings. So these are the three main reasons why the pleadings are significant: to freeze the dimension of the case, to give a fair notice to the other party as to what your case is going to be, and to make a list of the issues on which there is dispute. A party can submit evidence. I already said this, that a party can submit evidence only on the issues or points raised in the pleadings. But the converse is not true. A party does not necessarily have to submit evidence on issues or points raised by them in the pleading. So what happens is that the pleadings tend to be rather very lengthy, repetitive, and exhaustive. I have seen typically the SOCs go into 500 to 600 pages, that big, because there is no punishment for including something which you did not seriously want to address. But there is a penalty for not including something that you wanted to address. If you forget to include it, you can't raise it later. But if you include it and later on you don't want to raise it, you are free to do so. So they tend to be very exhaustive documents. Once the SOCs are submitted, now I am taking here only an example as if there are only two parties, but whatever I am explaining with two parties will equally apply irrespective of whether there are three parties, 4 or 5 or anything, correct? So let us say there are two parties, A and B. A submits the SOC to B and of course to the tribunal to B. B writes a reply to A's SOC. A again writes a counter reply, also known as rejoinder, to the B's reply, correct? So A writes the SOC and gives it to B. On that SOC, B writes a reply to A. On that reply, A again writes a rejoinder to B. Identically, B also writes an SOC and gives it to A. A writes a reply on B's SOC and B again writes a rejoinder to that reply. So each party replies to other party's SOC and each party writes a rejoinder to the replies by the other parties. With two parties, this is only as much as you can see. As the number of parties increase 3, 4, 5, it becomes a polygon, multinodal polygon, and the number of documents increase, but the process remains the same. Now, a while ago, I said that the SOC is the pleadings of the party. Strictly speaking, that is correct. Strictly speaking, only the SOC is the pleadings. But tribunals have a little bit of discretion, and they often allow the reply and the rejoinder also to be considered as the pleading. So the SOC of A, the rejoinder written by A to the reply by B, and the reply by B written to the A, these form written to B on their SOC, these form the pleadings of A, and likewise the SOC, the rejoinder and the reply, they form the pleadings of B. And like that, every other party have their own pleadings. Now, for the reason I explained to you, the SOC is an exhaustive statement of case. The reply to the SOC is typically deny everything. If one party says that I need to construct this dam in order to irrigate such and such area, in the reply, the other party will say it is hereby denied that they require to construct this dam to irrigate such and such area. Just go on denying everything. You don't have to prove it now. Proof comes later. In the reply, you just typically, there isn't much explanation. Tendency is to simply deny whatever the other party is asking. Likewise, in the rejoinder, typically the first party reiterates everything. So in the SOC, if A has written that I want to construct a dam at place X and use a quantum of so many MCM of water to irrigate such and such area, in the reply, the other party will say it is hereby denied that they need to construct this dam. It is hereby denied that they have right to use that much quantum of water to irrigate such and such area. And in the rejoinder, the first party will again say it is hereby reiterated that I need to construct this dam. It is hereby reiterated that I need to use this quantum of water to irrigate such and such area. Now you may ask, then why is all this gone through? Well, it has a legal significance. You said something, the other party was given an opportunity to respond to it in writing, and you also got an opportunity to further respond to it in the writing. Usually the matter ends here, but there have been cases recently in the context of an interlocutory application between Andhra and Telangana where there was a rejoinder to rejoinder called sub rejoinder. So there was a rejoinder to rejoinder, sub rejoinder, and a further rejoinder. It is up to the tribunal to either allow such a thing or not to allow. But the first three, that is the SOC, the reply, and the rejoinder are standard practice. Thereafter, if one of the parties wants to again submit a reply, it is up to the tribunal to allow it or to not allow it. Now, for example, A in SOC says that construction of a dam such and such would have a devastating effect. Construction of a dam XXX by B would have a devastating effect on me, that is on A. Typically, B in reply will say it is hereby denied that the construction of dam XXX would have a devastating effect on A. In the rejoinder, A will again reiterate it is hereby reiterated that construction of this dam by so and so would have a devastating effect on me. Right? No one has to prove any of it now. At the moment, you are only creating issues. Proof comes later. Now, completion pleadings have been completed at this stage, and an important landmark is reached. While all this is going on, the parties may submit interlocutory applications. To repeat, an interlocutory application is an application for seeking some quick relief from the court or the tribunal in a case which is already going on before the tribunal. Typically, the IAs are for interim relief. An interim relief is a small temporary relief granted with inadequate scrutiny. It is very clear that the interim relief is granted with inadequate scrutiny. Why inadequate? Because if you apply adequate scrutiny, then it will take as long as the main matter takes. Main matter is going to take, let us say, 5 years. In the meanwhile, you want a little amount of water as an interim relief. If that too is subjected to the same level of scrutiny as the main matter, then that too will take 5 years. So interim relief is granted with inadequate scrutiny and may be given if three main conditions legally are satisfied. The first condition is that the party should be able to establish a prima facie case. You can't simply say that I want so much water as an interim relief. At least a prima facie case you have to establish why you need that interim relief. The second is they have to prove grave and irreparable injury if the said relief is not granted. The word injury is used in the legal domain to mean a loss or a damage. That is, I am asking that please give me 5 TMC of water as an interim relief. So I have to prove as a prima facie case why I need that 5 TMC of water. Then I have to also prove that if you do not give me this interim relief 5 TMC of water, then very grave and irreparable loss will happen to me. And the third is, I have to prove balance of convenience in my favor. What is this balance of convenience? What will happen is that if I say that you must give me 5 TMC of water, otherwise I will die. The other party is going to counter by saying, if you give him 5 TMC of water, I will die. दोनों कह रहे हैं कि मुझे पानी नहीं दोगे तो मैं मर जाऊंगा, वो कह रहे हैं कि इसको पानी दे दोगे तो मैं मर जाऊंगा. Now, whom does the court, let us say, give more weightage? That is called balance of convenience. The party who appears to be suffering a greater injury, if their relief is not granted, the balance of convenience is in their favor. So while both parties may argue that if this is done or this is not done, I will suffer, the one who will suffer more, the balance of convenience is in that party's favor. So if a party is able to establish a prima facie case, grave and irreparable injury if it is not granted, and the balance of convenience, then the court may consider giving them an interim relief. 2 more requirements are usually required to be satisfied. First is that interim relief sought should be much less than the final relief. This is obvious. Supposing I am contractor and you are the department and I have submitted a claim of say 10 lakhs to you, that over and above the bill, there is an additional claim of 10 lakh rupees. And it is going to take 3 years to adjudicate. And supposing if I ask that, therefore give me 8 lakh rupees as interim relief, and if it is given, then probably I will lose interest in the case. Because probably my real claim was never 10 lakhs, it was only 8 lakhs. I had inflated it to 10 lakhs. And if you give an interim relief, which is very close to the final relief, I will lose interest in the case. I will not even appear before the court hereafter. So obviously, interim relief, which is granted with inadequate scrutiny, cannot be close to the final relief. Second, it should not create a fait accompli. I can't ask that I be allowed to construct a dam as an interim relief. Because if you allow me and I construct the dam, then afterward I will say, oh, but however, I have spent 500 crores of public money, now you can't demolish it. So it should not create a fait accompli. Subject to these 5 conditions being satisfied, the court may consider granting a interim relief. The IA, that is interlocutory applications, are generally supposed to follow the same path. That is, there should be a SOC, reply, rejoinder, etc. But the depth of scrutiny is much less. There is no framing of issues formally. Usually they have one single issue at focus. There may not be evidence, no cross-examination. It straight away proceeds to the stage of arguments. Sometimes, if the matter is very small, there may not be even reply rejoinder complete. Just one reply and the court may start hearing it. Okay. Now, so pleadings have been completed and simultaneously some hearing may go on in on the IA. Next stage is the framing of the issues. Every assertion by a party which is denied by the opposite party can give rise to one or maybe even 2 issues. Some issues are specific to a party, some are common. A says in the SOC, construction of the dam by B would have a devastating effect on B. B in the reply says it is hereby denied that the diversion of water by B in that dam would have a devastating effect on A. Now the burden of proof is on A. It is for A to prove that if he uses that much water from that dam, there is no devastating effect on A, that he has the right to use that dam, to use that water. So the tribunal will frame an issue for A, whether A proves that the diversion of water by B would have a devastating effect on A. So A has to prove it. Some issues can be for the both. For example, supposing there is an instance of diversion of water outside the basin. One party may plead, diversion of water outside the basin requires consent of all the basin states. Other party may plead, it is hereby denied that diversion of water outside the basin requires consent of all the basin states. Here the burden of proof may be on both. Party A has to prove by evidence or by whatever arguments that the diversion requires consent of all. Party B may have to prove that the diversion does not require consent of all. Right? So burden of proof is on both. The issue may be worded like this: whether diversion of water outside the basin requires consent of all basin states. Now, in the recent past, I have gone through the issues framed by three different tribunals: the Mahadai tribunal between Goa and Karnataka and Maharashtra, the Mahanadi tribunal, primarily Odisha and Chhattisgarh, and now the Krishna tribunal between Telangana and Andhra. And I find that the language used by the tribunals in framing the issues may differ quite widely. But basically, the idea is same. You pick out the main issues on which there are differences. Hereafter, all tribes will be only focused on these issues only. For example, another issue which can be common: what is the annual yield of the river? At 90% dependability, 75%, 50%, etc. So each party may submit a hydrological study to put forth their own view as to what is the yield of the river. The issues framing process is also with a hearing. The parties may be asked to first submit draft issues, or the tribunal may draft some issues and give it to the parties. Then there can be open hearing on the issues. The parties may suggest a little change here and there, add an issue, delete an issue, modify the language of an issue, and after this, finally the tribunal will freeze all the issues. Now, some issues pertain to science and technology, and some are legal. The issues pertaining to science and technology are usually proved by experts, subject matter experts, through evidence and studies. For example, what is the extent of contribution by different basin states in the total flow of Mahanadi River, and what would be its relevance for equitable distribution of water? This is the actual issue from the Mahanadi Tribunal which I had taken, actually worded as it is. I have used two different colors because they are two different things. Issue is one: what is the extent of contribution by different basin states to the total flow of the Mahanadi River is a purely technical matter. You have to conduct the hydrologic studies, gather all the rainfall data, runoff data, etc., and conduct a hydrologic study and come out with what is the extent of contribution by each state to the total flow of Mahanadi. And the next question is, what would be its relevance for equitable distribution of water? Do the state get a share of water in proportion to their contribution, or something else? This is not a technical matter. This is purely a legal matter. So while the blue part would be proved by the experts through hydrologic studies, the red part would be argued by the legal team at the stage of arguments, right? Now, while the pleadings are being completed or after the pleadings are completed, another important stage takes place called interrogatories or discoveries. This is the stage where each party can seek data and information from the opposite party. The purpose of this is that when you take up an hydrologic study or some other study, you may require data which is in the territory of the opposite side. So unless you have that data, how can you complete your study? Say, for example, in Mahanadi, I want to argue the impact of backwater flow of Hirakud Reservoir in Chhattisgarh, for which I require the Hirakud Dam operation data, inflow, outflow, gate openings, and so on and so forth. But the Hirakud Dam is in the territory of Odisha. I do not have that data. So unless Odisha gives me that data, I cannot do my study. So the procedure allows that I seek this data from the state of Odisha. Likewise, they can seek any data they want from us. This is somewhat like RTI, but much more formal. If you have the data, you have to give it. If you deny that I don't have this data and later on it comes to light that you had this data, but you concealed it, then the consequences can be very serious indeed. And all the data submitted to the other party, and of course to the tribunal, because I already explained that everything is submitted to everyone, has the status of, you can say, sworn affidavit. So you can't just submit something lightly and later on say, no, I made a mistake. So these interrogatories and discoveries stages going on simultaneously. Quite often, the data may be quite large. Collecting it may take a lot of time, but it has to be given. After that comes the next stage, that is the evidence. What is the annual yield of the river at 90%, 75%, and 50% dependability? I am taking an issue, for example. This is an issue frame. Evidence will be a hydrologic study. So each party will summon one or more hydrology experts. They will conduct a detailed hydrology study and finally submit a report as to what is the 90%, 75%, etc. dependable yield. Likewise, evidence will be submitted on all the various issues. Then starts the stage of cross-examination. And this is where the real fun starts. I mean, fun I am putting in inverted commas. So far, it was all very logical and reasonable. Now the problems start. But first, let us look at the process. Cross-examinations means the expert who did that study appears as a witness before the tribunal and is cross-examined by the advocate of the other party. In the end, the judges may also ask some questions. But I think when the judges ask the question, it is not called cross-examination. Cross-examination will be by the other party. This is called recording of evidence. The witness is cross-examined. His answers are written in real time. The two tribunals that I have been gone through and where I have been a witness, in the Krishna tribunal as well as in the Madhai tribunal, they erect a large, either a LCD projector or a large 42-inch TV screen. A steno sits there. A question is put to you. The question is typed and displayed on the screen. You give your answer. The answer is also typed in real time and displayed on the screen. You can edit it if you like. But once you edit it, and like Kaun Banega Crorepati, once you lock it, then after that you can't even change one comma in it. At the end of the day, the whole thing is printed and you have to sign it as accepted. So this is called recording of the evidence. There is much more to say about the cross-examination that I will come later when I analyze the process. After the cross-examinations of all the witnesses of all the parties are over, then the advocates of each side may make oral arguments. This is where you sum up what the other party has said during the cross-examination or in the evidence. See, initially there was SOC, reply of rejoinder. Then the issues were framed. Then each party submitted their evidence and the evidence was examined. But the legal team hasn't yet had an opportunity to either counter the evidence submitted by the other party or emphasize the evidence submitted by their own experts. That happens during the oral arguments. Also, at the end of oral arguments, the parties may submit written submissions summarizing the oral arguments. You might have read yesterday the hearing in the Supreme Court on the Article 370 was finished. Oral arguments were over. The Supreme Court has reserved their judgment. They have given the parties appearing on this Article 370 1 week time to submit, if they want, a written submission not exceeding 2 A4 pages. So this is because, after all, judges are also human beings and they can't take notes so fast. So you may say so many things. Some of them may be lost in the memory. So you are given an opportunity that submit in 2 pages all the important issues in your arguments, and then they will analyze it and give the judgment. In the case of river water disputes, this written submission may be much more than 2 pages because there is a lot of technical matter, but there could be written submissions. Here the trial ends. The tribunal then adjourns for a few months, analyzes all the data and the evidence and everything, and then comes out with the decision. This is actually called a report. We call it award, but it is not the awarded yet. This is called a report which they send to the Ministry of Water Resources. Then start the Section 5(3) proceedings. The parties are allowed to seek clarifications on the report given by the tribunal. Sometimes the Ministry of Water Resources, that is the union government, may also jump into the ring and also seek some clarifications from the tribunal. Then again, the similar kind of proceedings, but though much low profile will start. Again, parties will argue, put forth some more documents and evidence. These are called 5(3) proceedings, Section 5(3) proceedings. And finally, the tribunal will send a further report based on the 5(3) proceedings. Eventually, the ministry will notify the report and the further report in the official gazette, and then it becomes the award, which is final and binding on all the parties. Correct? Sounds very logical and simple, does it not? But does it work that way? No, obviously not. All of you are professionals in the water sector. The original act gives 3 years with maximum 2 extension of 1 year each. That is maximum 5 years for the tribunal to give their report. But it rarely happens within 5 years. I think Vamsadhara and Mahaday are the only 2 tribunals which recently finished their work in the given time of 5 years. All others had taken maybe even 10 years. Secondly, although in the end I say the decisions are final and binding on all, but there are SLPs pending, special leave petitions pending in the Supreme Court. So the process explained by me so far sounds very logical and simple, but it certainly doesn't work the way it is intended. And why not? So I have finished about 40 minutes of my time, and let us spend another 20-25 minutes in trying to analyze all this, why it doesn't work the way it should. This is because litigation, and particularly the adversarial litigation, is not a well-suited procedure to decide science and technology issues. These are all my own, you can say, views formed after being in this business for 10 years. I started Goa work in 2013. We are into 2023. So I have completed 10 years doing this with Goa and continuing. Tomorrow there is a meeting with the Advocate General of Goa, and then on Zoom. And on 15th, there is a meeting in Panji. So Goa work continues for 10 years. Meanwhile, in 2018, I started advising government of Chhattisgarh on Mahanadi dispute. Now I have gone through the process of being an expert witness for the state of Telangana in the Krishna dispute. And after these 10 years, I have, you can say, extracted some views which I am placing before you. Litigation, basically a river water dispute is primarily a technical issue. What is the yield of the river? How much is the groundwater? And these are all technical questions. And it is my opinion that litigation, and particularly the adversarial litigation, is not the correct procedure to decide science and technology issues. Now, litigation is basically of 2 types, adversarial and inquisitorial. Adversarial litigation is that where the opposing sides appear as adversaries who compete to convince the judge of their views. The judge acts as a passive referee. Passive is important. They listen to both the parties. They are neutral, but they are passive. They are not active. Supposing, for a moment, assume that a judge is originally a civil engineer, after which he did law and became a judge. So he understands what is 75% dependable flow. And he finds that there was something evidence which should have been submitted by a party, but they did not submit it. In adversarial litigation, it is not for the judge to remind that party, "Arey, you should have said that. Why have you not done that study?" No, it's not for him. In adversarial litigation, the judge is a passive referee. You will recall a celebrated case, one Jessica Lal murder case, where initially the trial court acquitted the accused, saying that the evidence is not before them. Everybody knew who had killed Jessica Lal. Everybody knew what evidence should have been produced, but the CBI did not produce that evidence. And the judge could not demand it, because this was adversarial litigation and the judge has to be passive. In contrast to this, the inquisitorial litigation is an inquiry by the judge into the case. So the judge is not passive. The judge can himself conduct an inquiry. The adversarial law originally started from UK, and therefore the countries that derived their legal practice from the UK, that is USA, India, etc., we all follow adversarial system. France, Italy, Germany, and some others follow the inquisitorial system. Now, adversarial system is based on the assumption that a struggle between or a debate between the counsel will expose the truth on the reality. But the reality is quite different. Since the evidence is provided by the advocate, inconvenient facts will get concealed. I as a technical expert, do not go directly to the tribunal with my study. I submit my study only to the legal team. They go through it, and only what they approve is submitted by the advocate on record to the tribunal. So if the legal team finds that something is inconvenient, they may modify it. So the truth doesn't really get revealed the way we think it will get. Further, it is biased towards the more competent attorney. I don't have to mention it. You all know the kind of fees the top lawyers nowadays charge. Why are these fees being paid by the parties? Because the process, a good study, a good hydrologic study, will need to be defended by a good advocate after the witness has done his job. If it is attacked by, conversely, if it is attacked by a good advocate, he may be able to demolish it. So the process is biased towards the more competent attorney. I would further say in the smaller box below, it is also biased towards the attorney perceived as more competent. Without going into the details, I think all of those who are in this business, they agree that the judges also sometimes feel overwhelmed by which advocate is appearing before them. One of the most senior person appearing and a junior person appearing, giving the same arguments, would have a different impact on the judge. On the other hand, the inquisitorial system depends on the specific judge's capacity and knowledge. If the judge is very knowledgeable in that area and is very active, he may be able to reveal the truth, otherwise it will not happen. So each system has their own plus and minus points. Proceedings are led by the advocates and technicalities score over merits. Now, you know, for those who do not know what is technicalities and what is merits, supposing A seeks 20 MCM of water as interim relief or whatever from B. How would B contest? If we were engineers, if left to engineers, we would contest it with arguments like they don't need 20 MCM or there isn't 20 MCM available at that point of withdrawal, or well, it is available, but we also need it and we need more than they do. These kind of arguments are called merits. But the legal team will have an entirely different approach. The tribunal has no powers to grant interim relief. They are not concerned whether 20 MCM of water is available, whether it is required. It starts with this tribunal has no powers to grant interim relief. They have no jurisdiction over the matter. Application of interim relief is not maintainable under section so and so, clause so and so. Interim relief cannot be granted because, and then they will give 20 reasons why it cannot be granted. They will never go into the merits of the case whether 20 MCM of water is required or is not required. These are called technicalities. There are two ways to defend a case, on merits or on technicalities. And invariably, I would say, in fact, not usually, invariably, the technicalities will score over the merits. It is my considered opinion, after being a witness 3 times and having seen other witnesses being examined and having been the assistant to examine opposite side witness, that affidavits and cross-examination is no way to decide the science and technology issues. Why? There are many flaws. First, an affidavit is something you can submit only once. There is no opportunity to correct a genuine error. And the disagreement is shown as error. Let us try to understand each one of them. Supposing you are Chief Engineer CWC, I am a department of the state government, and I bring a DPR to you with a hydrology study. In this DPR, I use 10 rainfall stations. You examine the DPR and you find that out of 10, you do not agree with one station. You think that the data of that one station is not reliable. What would you do? You would return the report to me and you would say that, look, Mr. Pandit, everything is fine, but you have used the data of this station X. I don't think station X is reliable. It doesn't pass the reliability check. So I will go back. I will remove the station X from my data analysis. I will redo all the calculations, submit again. This is how science and technology proceeds. But that is not what it happens when it is the same study is submitted as an affidavit. As an affidavit, I don't have the opportunity to say, all right, come on, give it back to me. I will just correct that error and bring it back again. No, I submitted it and that is the end of the matter. It is like an exam in which you can appear only once. If you fail, you can't appear in this exam again. There is no opportunity to correct even a genuine error. And a disagreement is shown as error. I'm going to dwell a little more on this. A disagreement is shown as an error. The environment is hostile. You are all, particularly from the state government, are familiar with approaching the CWC for the approval of your DPR. Your DPR may get approved or may not get approved. That's a different case. But the CWC is not a hostile environment who are somehow out to prove that your DPR is wrong. In contrast, a cross-examination is a hostile environment where the other side is out to prove that you are wrong. In fact, if you look up on the Google how to conduct a cross-examination, the advice given to the advocates, learning advocates on the Google I found are very interesting. One of the important advice is never ask a question unless you are sure the answer will be in your favor. ये क्या हो रहा है? ऐसे कभी साइंस एंड टेक्नोलॉजी एग्जाम में होता है? Never ask a question unless you are sure that the answer will be in your favor. Anyway, examining advocate's objectives are to trap the witness into admitting his, that is, other party's case. I have said something. If he can somehow trap me into admitting the opposite of it, then his case gets proved very nicely, because the other party's witness has admitted what he wants to argue. Nothing better than this. If that doesn't work, then it's his attempt is to show the witness as incompetent and to prove that his conclusions are incorrect. Basically, the idea is to demolish the report. Now, unfortunately, the way things go, it is not necessary for them to prove that there is some mistake. If supposing I indeed made a mistake in my hydrology report, well, that is so well and good. Then of course they will point it out. But even if I have not really made any mistake, it is sufficient to raise doubts and influence the judge's mind कि कुछ तो लफड़ा है, without proving anything. If nothing works, they will try to discredit the witness. And that is the second point. You will be surprised. Go back and search on Google. First advice to the advocates is never ask a question unless you are sure the answer will be favorable. Second is try to discredit the witness. Is this the way to decide the 75% dependable yield in the river? But that is how it goes. The witness is in an extremely, you can say, unfavorable position. He cannot argue. They are having so many occasions where I wanted to take up the argument with the advocate, but I know that I'm not allowed to argue. I can only answer questions. I cannot even explain adequately. Invariably, at the beginning of the cross-examination, the chairman of the tribunal or one of the judges will give a small set of instructions to the witness. And one of the common instruction always is, please be brief in your answer. If you try to give a lengthy answer, we will cut you short. And they actually do it. I have been cut short on many occasions. And I can't even say, my lord, please let me complete. If you allow me to complete, you will realize that I was not speaking unnecessarily. But you can't even say that. So you can't explain adequately. The witness has to be extremely careful not to annoy anyone, and particularly the members of the tribunal. Sometimes you want to say something. I wish I could go into the details and cite specific examples, but the cases where I'm appearing are not over. So I must also exercise some restraint. But there are often situations where you know the correct answer, but you can't say it out. Because you know, if you say the correct answer, give the correct answer, it will annoy someone. So you have to just swallow it. Therefore, often you cannot say what you want to say. Now, this kind of thing is inevitable because the starting premise says that this is adversarial. The two sides are adversary. They are not cooperating in trying to find the truth. They are adversaries to each other. So all these deficiencies are unavoidable. Yeah, the procedure, say selection of rainfall stations. Now, a while ago I said that you don't have to prove something wrong. You can even create doubts and that is sufficient. Let us take a specific example. All of you know enough hydrology to know that normally you have data of, let us say, 20 rainfall stations, out of which you have to select the one which are relevant, which influence the catchment, whose data is reliable, consistent, etc. Supposing I have not used the data of Rohtak station. I am deliberately taking a station as an example, which is at the moment not involved in any dispute, kind of neutral. Okay. Supposing I have conducted a hydrologic study and I have not used the station data of the Rohtak station because I feel that the station data is not relevant or the data is not consistent, not reliable, etc. The question put to me will be, you have not used the rainfall data of station Rohtak. Why have you ignored the data of Rohtak station? Now look at the language. Ignored. biasing the mind of the judges starts from here. A picture is being made that I ignored it. I not ignored it. I excluded it. There is a difference. Ignoring something and excluding something are two different things. I will try to calmly reply. I have not ignored the data of station Rohtak. I had checked the rainfall data at all the stations for consistency. Details are at page so and so of my report. Data of Rohtak did not pass the consistency check. Therefore, I rejected it, did not ignore it. He will completely ignore the part of my reply where I refer to the consistency check. And he will ask next question, can you quote any scientific literature that says rainfall data at Rohtak is inconsistent? Obviously, you know, I can't quote such a paper. People don't write paper to say the data of this station or that station is relevant or irrelevant, consistent. That may come as a part of some hydrology study. Merely the examining the data of a station is not a part of the a paper in the seminar. Moreover, his technical team yesterday night has already done a Google search to verify that there is no paper on the internet available, easily available, which says that the data of Rohtak station is inconsistent. Knowing this, that I cannot give a favorable answer to me, he asked the question. I cannot answer it. This will go on for a while. Finally, it will end with, I put it to you that you have rejected the rainfall data at Rohtak station, despite the fact that there isn't even a shred of scientific evidence to support your conclusion, only because rejecting the rainfall data at Rohtak benefits your client's state. What do you have to say? At this stage, you want to scream and say hundreds of things, but you can't say any of them. And in case some of you are wondering that whether this cross-examination goes for a day or two, it goes for months. It doesn't go for days, doesn't go for weeks, it goes on for months. I think the most recent was my cross-examination in Krishna, which was the shortest. It started in October and ended in May. October last year and ended in May this year. Sorry, March this year. So he will never refer to the consultancy checks by me. Instead, he will ask me to submit a paper which he knows doesn't exist, and so on it goes. This is because the whole process, which is probably borrowed from the criminal law and the civil law, is based on trying to find the facts to decide something as true or false. But you know, in science and technology, there are no facts like that. Everything is not true and false. First, let us take an example from the criminal or so. There is a question, accused was present at the site of the crime. It is either true or it is false. He was either present or he was not present. You can't say maybe he was present, but not entirely. No, there is no such thing. Likewise, bullet was fired from the gun owned by the accused. Either it was fired or it was not fired. And so on. Fingerprints match those on the butt of the gun. Either they match or they do not match. But apply the same logic to rainfall data is available from 1901 to 2015. X uses data from 1960 to 2015. Y uses data from 1970 to 2015. Use of data between 1960 and 70, 10 years data, is correct, true or false? No, it's neither true nor false. These are the two judgments of two hydrologists and they are both correct in their own place. X, who used the data from 1960 onwards, he is also right in his judgment. Y also is right in his judgment. These are not binary things to be proved right or wrong. But that is how the system treats it. Probably because that is what they have been accustomed to it all their years in the court and on the bench. Similarly, rainfall data at some station X is or is not reliable. It will happen quite often that I will use data of some 10 stations. My opponent, a hydrology expert, will use data of some 9 stations, 10 and 9. 6 stations may be common to each, but he will use 3 stations differently. I will use 4 stations differently. That happens. Runoff factor is a common point of dispute. Somebody will say that years with runoff factor more than 0.65 should be rejected. Some will place it at 0.67. Crop water requirement. All these are opinions. They are not facts. But the system tries to prove them as facts, and that doesn't work. So the whole attempt is to either the entire study stands or it falls, collapses. But this is not how the technical domain works. As I gave you an example, if I go to CWC with a DPR, CWC may say, well, you have used the 9th station, I agree with it, but I disagree with one. Filling of the missing data, I agree. This I agree, that I don't agree. So I go back, make the changes and resubmit. But here there is no such opportunity. Now, since the witness could not justify his not using the data of the station Rohtak, if the tribunal agrees with that assessment, that I should have used the data of Rohtak, they will not call me back again and say, all right, you should use the data of Rohtak. Now use it and do it again. No, my entire report is rejected forever. Not only my report is rejected, my party state also cannot say, all right, we will get another expert and he will do the study again. No, it's a once in a lifetime kind of thing. Karo ya maro. Although he is called an expert witness, but everything he says has to be proved. Nobody really takes you as an expert. Here is an example, actually from a question asked to me. In the Mahadai tribunal dispute, I said at one place in my affidavit that the sum of the, it is a known fact that the sum of the 75% dependable yield for sub-catchments does not equal the 75% dependable value for the whole catchment. And we all know this. This is the basic truth. If you divide the catchment into several sub-catchments, calculate a 75% dependable yield for each sub-catchment, add it up, and also calculate a 75% dependable yield for the entire catchment, it is not going to match. Why? That also we all know. But the question was put to me. Is there any scientific established theory that 75% or 50% dependable yield for the whole, if distributed over the parts, will not equal the 75% or 50% dependable yield computed for the parts separately? I am not allowed to say that I, as an expert, I am telling you this is the case. I have to prove it by quoting somebody else, which is very funny. I can download a paper from the Google and that will be accepted as a scientific fact. And it is very infuriating that some XYZ unknown person on the Google, whom we have never seen, you do not know his credentials, qualifications, experience. His paper downloaded from the Google is scientific evidence. But this fellow Chetan Pandit standing before you, his CV is before you, experience is before you, he is not accepted as an expert. तो ये expert witness तो हम लोग कहने को होते हैं, कोई हमें expert witness accept नहीं करता है. So, a advocate reaches. Now we do the same thing to their hydrology report when our turn comes. They try to tear into me, we try to tear into their expert. So they try to make our report collapse, we try to make their report collapse. Then what happens? Then nothing. Everything has been destroyed. Now what? Now the answer to now what is not easy. In case of Mahadai, the tribunal did their own study and nobody accepted that study. So everybody has gone to Supreme Court with an SLP on that study. SLP is a special leave petition. And as you know, this is basically a provision given by the Constitution that supposing you are a certain court or a tribunal has given a decision against you and you feel that you great injustice has been done to you, but you are not even allowed to file the appeal before the Supreme Court or the next higher court. Then SLP is a special provision where you can go to the Supreme Court with a plea that look, great injustice has been done to me and I'm not even allowed to appeal to you. So please give me a special permission to appeal to you. This is the basic concept underlying the SLP. Now, the Interstate Water Dispute Act is very clear that there is a bar on jurisdiction on Supreme Court and any other court. Not what it says, I'm reading from the Act, notwithstanding anything contained in any other law, neither the Supreme Court nor any other court shall have or exercise jurisdiction in respect of any water dispute which may be referred to a tribunal under this Act. The initially Krishna Dispute Tribunal 1, the Godavari Tribunal, the Narmada Tribunal, they all went through flawlessly. Nobody went to Supreme Court with SLPs. But then it all started with Kaveri, where Karnataka filed a SLP before the Supreme Court. The central government jumped into the fray and tried to argue before the Supreme Court, my lords, please don't entertain this. If you entertain this, it will lead to a scenario which will be very difficult to manage hereafter. but the Supreme Court did not accept that, and they admitted the SLP by the Karnataka. Now, in case of Kaveri, it so happened that the SLP was for a very minor modification. Karnataka wanted a little quantity of more water. It did not require, you can say, re-examination of the entire witness, the evidence, the hydrology study. A little minor adjustment was required. The Supreme Court granted that one way or the other, and the matter came to an end. But a precedent got established that you can go to Supreme Court with a SLP, even against a decision of a water dispute tribunal, even though it is barred in law. Now what is happening is, in Mahadai, the entire award has been challenged. In Krishna, the publication of KWDT2 award has been stayed so far. Now take Mahadai case. What will happen hereafter? The Mahadai Dispute Tribunal gave their decision in August 2018. Immediately SLPs were filed by the Maharashtra and Karnataka. We Goa filed it a little later. But let us say Karnataka SLP was immediately filed in 2018 itself. Today we are in 2023. Hearing has not even started. We give 3 years to the tribunal to settle the dispute, 2 years of extension, and in the new bill this is going to be further reduced actually. I think total 3 years or thereabouts, 3 or 4 years. 5 years, even the hearing has not started in the SLP. Okay. Even when it starts, then what happens? These are intricate technical matters. 75% dependable flow kya hota hai? It takes a long time when we deal with the advocates. It takes a long time for us to even explain the concept of 75% dependable flow. Quite often you have to start with explaining the difference between million cubic meter and cubic meter per second. Obviously, because you see, just as we are not law experts, they are not technical experts. I presume, not that I know, but I presume the judges would be taking similar help from the assessors appointed to help them in understanding the technical matters. But there are no assessors in the Supreme Court. Now, will the Supreme Court call and examine the expert witnesses again? But normally that doesn't happen. Supreme Court doesn't examine the witnesses. Will SC go into the evidence? All right. Not examine the witness. Will they take all the evidence, written evidence, and study it? Probably not. It is too voluminous. Then how will the Supreme Court decide the challenge of the yield study? I will tell you very specifically. The Mahadai Tribunal rejected the runoff data of CWC at the only station available. And they used the English formula, that is runoff is equal to 0.85 multiplied by rainfall minus 305. 1946 formula derived by English to we have use of English formula. How will the Supreme Court decide whether use of English formula is correct or is not correct? We do not know. Nobody knows the answer to this question. So somehow the justice delivery mechanism has taken us into a domain where we do not know what is going to happen further. The SLP in the Mahadai case is pending for 5 years now. I believe there is not one but many SLPs in the Krishna case. They too are pending before the Supreme Court for several years. If I remember correctly, one of them is pending for probably 5 years or even longer. And nothing is getting resolved. This is where the matter stands. Actually, I started with a decision to only explain the process. But in the end, I have even made some comments. There is a new bill before the Parliament, has not yet been approved by both the houses of the Parliament. But supposing it is approved, then what happens? Do we have high hopes? I have absolutely no hope that anything will change. What does the new bill do? It reduces the time limit from 5 years to something like 3 or 4 years. It says that instead of constituting a new tribunal for every dispute, there will be a permanent tribunal. And like a court, today they hear one dispute, tomorrow they hear another dispute. Like that, there will be benches. Who will dispute here Mahanadi today, Krishna tomorrow. The judges will have a more permanent tenure. The assessors will be from CWC. But all these are not the ills of the system. The reason today the water disputes are not getting settled is not because the assessors are not CWC officers or because the judges. In fact, the judges will be overburdened in the new system when the same judge may have to hear two different disputes. Presently, one judge is only in one tribunal hearing only one dispute. Even then, it doesn't end in 5 years. So the real ills of the system have not been examined, have not been addressed, and I do not have any hopes that the new system will change anything. And even if the decision comes, whether after 3 years or 4 or 5 or whatever, there still will be a SLP. And then what happens after that? We do not know. Well, this is not all. I have a plenty to say, but this is all for now. Thank you for a patient hearing. Now, in case the admin has muted everybody, you may please unmute. And the floor is open for questions, comments, anything. It's 14:10. I think I have finished about 5 minutes before my time, and we have got time for questions. Yeah.
Yes, sir. Yes, sir. Sir, in chat box, there are two questions. One question is constitutional dimensions are at the base from where business of ISWDT emanates. What's your view on Article 262(2) versus Article 136? And second question is, do tribunals have powers of contempt? If not, should it be there? Sir, question is in chat box.
I know. I have opened the chat box. Actually, I'm trying to maximize my screen.
Yes.
Somehow that is not happening because I'm only seeing a very small. Anyway, first question is, oh, it's my friend Shavaik. Shavaik, that's unfair. You should not ask legal questions to me.
It's only coming from, Namaskar, sir. It's only coming from your vast experience, and we are here to learn from you, sir. So, if you want me to explain a bit, I can, but I think you understand it very well.
Your first question, your one question, whether the tribunal should have the contempt of court power.
No,
I
so
think they have, because what I understand is,
yes.
What I understand is that a tribunal has got all the powers available to a civil judge. So they have contempt powers also. As regards your second question, Article 135 or whatever, no, I don't carry the Constitution in my head the way I do with hydrology. I will have to refer to the Constitution and answer. And I'm sure you don't want me to answer that.
No,
I
don't want to answer it. Only, sir, you pointed out a number of provisions in this act. There are two provisions which say that one uses the word force, that the tribunal constituted under the Interstate Water Disputes Act will have the force. Its decision will have the force of the decree of the Supreme Court. In
Correct.
Article 9, it says that it shall be enforced as the decree of the Supreme Court. So once it has the equivalent power to the Supreme Court by virtue of the act itself, where is the space under 262 to go to the Supreme Court and entertain?
Exactly, but that is what is happening.
Yeah, so in 136, sir, there is the military tribunal has been exempted. So inherent powers of the Supreme Court for SLP under 136, there is one exception to it. It can entertain all kind of appeals, but it cannot entertain court-martial and a military tribunal appeal. So what I was trying to say and contemplate and hear from you is that should a interstate law, since it is in contemplation under since 2017, a new act, should it be imagined in a way where no Supreme Court business is envisaged, because it does not stop anywhere then?
But I think that is already written there, that no court shall have any jurisdiction. And not only that, when Justice Deepak Mishra,
Sir,
the justice in the concern was Justice Deepak Mishra, when Karnataka submitted their SLP on the Kaveri matter, the union government jumped into the fray as an interested party and tried to argue before the Supreme Court that my lords, please do not entertain this, but they did not listen.
right.
So that's it.
Okay, maybe I'll find the opportunity to discuss this with you personally. Thank you. I'm satisfied.
Yeah, sure.
Thank
Sure.
you. Thank you.
Sir, next question means he just asking the proposed amendment to ISRWT Act 1956 provides for one member of tribunal as technical expert. I think it would help in looking technical issues more fairly and correctly. Miss, he is saying, but he has doubt whether it correct or not.
I don't think we can take a view on that either way, because that entirely depends upon who that person is and what is the internal relationship between the three members of the tribunal. That is the technical member and the two non-technical members. Personality wise, supposing some technical member may be kind of a person who is assertive, he may be able to have his say. Somebody else could be rather timid, he may not be able to have his say. So that entirely depends on the personalities. This question doesn't have a unique answer.
Thank you, sir.
And I mean, you can say even in any ordinary situation, say there is a DPC, Departmental Promotion Committee, or any such committee where there are people from different, who will get his way around depends upon how assertive the person is.
Thank you, sir. Next question is, can assessor appointed by tribunal carry out independent studies and suggest appointment mechanism to the judges of the tribunal?
Suggest appointment mechanism. What is appointment mechanism? Apportionment. Sorry. Apportionment mechanism. As for carrying out the studies, they certainly can, although it would not ever come to know, we would not come to know that the studies carried out by the assessors, but certainly they can. I told you that in the case of Mahadai, the tribunal rejected all the studies, not only by me. I did the Goa study. They rejected my study. They rejected Professor Gosai's study appearing for the state of Karnataka. They also rejected the expert from Maharashtra. And then they used the English formula and an entirely different rainfall data. They rejected all the station rainfall data by the IMD and used what is known as grid data. And using the grid data and applying the English formula to it, they conducted their own study. So certainly they can do it. Presently in the Mahanadi tribunal, which is going on, the assessors have asked for a huge amount of data. And I believe that they are going to conduct some conceptual model like, I don't know which one, weak model or any such thing. They are going to apply a model and do their own study. So there is absolutely no bar on the assessors doing their own study, but it will be considered as an advice to the judges, input to the judges. Does that answer your question? The second part, suggests apportionment. Certainly, I mean, I'm sure at some stage the judges would ask for their views, but to what extent their views will be accepted with or without modification depends on the judge. And now, appearing before the Krishna tribunal, I find that the chairman of the tribunal, he has been the chairman of the Krishna tribunal since its inception in 2010. So for 13 years, he has been hearing these matters. So now that person is very, very knowledgeable. That may not always be the case when there is a judge very new. He may not be so knowledgeable. All these are matters of interpersonal equations.
Thank you, sir. Yes. Any more questions?
Yeah, can I ask Pandit
Yes, sir.
Sir?
Yes, sir.
Yes,
Very well, sir.
I recognize your voice. It hasn't
yes.
changed over the decades.
I want to know your experience. What kind of a change you suggest now in Central Water Commission, so that whatever they project or whatever they use becomes more acceptable as in the final round? I mean, I'm interested to know. Certainly, there is a need to review within CWC working, which should be more towards the outcomes, which or the experiences which you are facing.
Answering in the context of interstate water dispute, I don't think CWC has much of a role. The law provides, the procedure provides that the chairman CWC will try to bring about an amicable settlement between the two parties, but that doesn't happen. In the case of Mahanadi dispute between Odisha and Chhattisgarh, the then chairman of CWC called a meeting, I think once or twice. One of the parties did not even attend the meeting. What can he do? So I don't think that CWC has much of a role. It is the legal, all the problems that I find with the Interstate Water Dispute Act resolution mechanism are problems with the legal system or the justice delivery system, and not so much with the CWC or with the Ministry of Water Resources. Yes, To some extent, I would say that the Ministry of Water Resources hasn't always acted as an impartial and neutral agency, which it should. And there are many cases on record for this. They don't appoint a tribunal in the time they should. The Ministry of Water Resources does not have any discretionary power whether or not to appoint a tribunal. Once a state approaches them with a complaint, they can only take a reasonable amount of time to see if an amicable solution can be found. And if such a solution can't be found, then they have to necessarily appoint a tribunal. There is no choice. But they don't. They didn't do so in the case of Goa. Goa complained to ministry, I think in 2004, and they kept the matter pending on one pretext or the another for 6 years, and finally constituted the tribunal only in 2010. Likewise, in the case of Krishna too, after Telangana was bifurcated into Telangana and Andhra, the question came, certain questions were referred to the tribunal. What these are is not relevant. What was not referred is relevant. Krishna Water Dispute Tribunal 1 had given 811 TMC of water to Andhra Pradesh, which now had to be divided between Andhra Pradesh and Telangana. Logically, this should have been one of the TORs in the Reorganization Act. But it isn't there. Why? We do not know. But it isn't there. Therefore, Telangana submitted a complaint to the Ministry of Water Resources that, all right, please divide the 811 TMC share between Andhra Pradesh and me. By all rules of fairness and also law, they should have referred it either to the same tribunal or constituted a new tribunal. That is their choice. But I think more than 6 or so years have passed, and it has neither been referred to the current tribunal nor constituted the new tribunal. Nobody knows who and when is going to divide the 811 TMC between the two states.
Actually,
So Telangana filed a SLP before the Supreme Court asking them only to direct the ministry to kindly refer the matter to a tribunal, not asking for water, only asking that a tribunal may please be constituted. So at some point of time, the ministry asked the Telangana government that you withdraw your case against us from the Supreme Court, then we will appoint a tribunal. After some consideration, some discussion, the case was finally withdrawn. Even then, the tribunal is not being appointed. So I would say it would be sufficient if the Ministry of Water Resources and CWC act in a neutral and impartial manner. But that will still not solve all the problems. States will continue to go to Supreme Court now with the SLPs. The matter will continue to remain pending there. And what happens, I don't know.
When I was asking this question, I was keeping in my mind the issues of our Indus Water Treaty, because we have already experienced the neutral expert and then we have experienced the court of arbitration also. And in both the situations, I have felt that if our studies at the DPR stage are done keeping in view that what will be their use or how they will be put to a scrutiny by legal system, then those documents can come to the rescue. Likewise, there should be a mechanism now built in the DPR so that this kind of issues can be addressed or can be answered by referring to some of those documents. Is that possible?
Tharaya Saab, I slightly differ with you on the Indus example, because I feel that the way an international dispute is handled is quite different from the way an interstate dispute is handled. In an interstate dispute, we are all the parties are the states of the nation of India. They are bound by the Constitution of India, by what the Supreme Court says. That is not the case at all in the international disputes. I believe, I do not know the details, you might know that in the recent situation, probably in the Neelam Jhelum project against Pakistan, who has simply boycotted the proceedings in the international court. That kind of opportunity is not available here. So, वहाँ पे तो, जिसकी लाठी वाली बात वहाँ पे होती है. The powerful nation can do anything they want. Also, another question for all of us to ponder is, why is it that the two nations are able to arrive at an amicable solution, whether they like it or not, but there is a treaty with Bangladesh, there is a treaty with Pakistan, a nation with whom we have fought bloody wars, killed each other's citizens, With them, we are able to enter into an agreement. But we are not able to enter into an agreement within the states in India, particularly in the peninsular India, where there is a severe water shortage. Why is it so? The reasons for that are many. My very brief comment on that is that in the international scenario, an agreement on sharing of water may encompass many other unrelated issues. That I will give you so much extra water at this place, provided you give me some other concession in some entirely another theater. That opportunity does not exist in interstate dispute. So, there is no leverage. One nation doesn't have a leverage against another. One nation has a leverage against other. One state doesn't have a leverage against the other. So I don't think here the matter is something entirely different. It is more political and legal system related rather than technical.
Okay, thank you.
Thank you, sir. Any more questions? If any questions, you can directly ask to our speakers.
Oh, there is a comment by Mr. Koteshwar Rao, who is the technical expert from Telangana leading their team in the Krishna dispute. He says Justice Brijesh Kumar, Chairman KWDT in chair from 2004, almost 20 years. Oh my God. That's quite a lot. So you see, yeah, some people, though they may be advocates or they may be judges, after a long time in this, they acquire some expertise. I remember in one case, the advocate from Karnataka, Mohan Katarki, quoted to me something from Ventecho. Now it is amazing that an advocate knows a book called Ventecho. But then again, Mohan Katarki has been in this since Kaveri dispute and many. So sometimes they may have some knowledge, but more often than not, they don't.
Thank you, sir. Any more questions? Yes, any questions?
Oh, there is one from Shrikant Patil. Oh, it's a comment, very informative.
Yes, sir. Yes.
Thanks, Mr. Patil.
Yes, any questions? Then we conclude the sessions. Okay. On behalf of National Water Academy, CWC Pune, I extend my heartfelt gratitude to our today's speaker, Shri Pandit sir, and also to all esteemed participants and attendees for joining us today for this enlightening webinar on Interstate River Water Dispute Act in India. It has been intellectually stimulating and enriching session where we had the opportunity to hear from renowned expert. His diverse perspective and values insight have shed light on complexities of water sector management and legal framework surrounding interstate river disputes in our country. We are extremely grateful to our distinguished speaker, Sri Pandit sir, for sparing his precious time and sharing his extensive knowledge and experience with us. Their comprehensive presentation have not only deepened our understanding, but also inspired us to take closer look at pressing challenges and potential solutions associated with equitable sharing of water through Interstate Water Dispute Tribunal. I would also like to extend special thanks to all participants who have actively engaged and involved in panel discussion and question answer session. Then furthermore, I would like to express our sincere gratitude to Chairman and ex-officio Secretary to Central Water Commission, who is driving force behind the various activities of NWA. I also thanks to Chief Engineer and Head of National Water Academy, Sri Chaskar sir. Last but not least, I would like thanks to our dedicated team of National Water Academy, the technical team and support staff who are tirelessly behind to make successful of this webinar series. In conclusion, this webinar has rightly emphasized the importance of collaboration, dialogue, and informed decision making when it comes to addressing interstate river water disputes. Our collective responsibility towards the sustainable water management and equitable sharing of resources has been reiterated, and with the knowledge gained from this session, we hope to work towards the effective solution. Thank you once again to everyone who had been part of this webinar. We look forward to future endeavor and collaboration in our pursuit of resolving interstate river water dispute in India. Thank you. There is one small announcement. Our next session will be on 14 September on Thursday, and the topic of webinar will be Interstate Water Dispute Act. And the renowned speaker to speak on this topic will be Advocate Ravindra Rao from Hyderabad. Okay, we will meet on 14 September at 11 a.m. Thank you. Namaskar. Thank you, sir.